A basic understanding of legal and ethical issues is important in every healthcare setting. The nature of the problems in psychiatric care elevates the significance of these issues. Patients in this population experience alterations in thought, mood, and behavior that may render them less capable of making appropriate decisions regarding their care. On the other hand, individuals with mental illness may need their rights protected through the legal system. This chapter introduces ethical concepts and legal issues that you may encounter in the practice of psychiatric mental health nursing. Ethical concepts. Well, no legal chapter would be complete without first discussing ethics, because laws tend to reflect the ethical values of a society. And ethics is the study of philosophical beliefs about what is right or wrong in a society. When you consider ethics, you are considering hard questions. For example, one big ethical issue that Americans have today is healthcare a right or is it a privilege? Now let's look at this slide here. Ethics, the study of philosophical beliefs about what is considered right or wrong in a society. Bioethics, used in relation to ethical dilemmas surrounding healthcare. And now ethical dilemmas, a conflict between two or more courses of action, each with favorable and unfavorable consequences. A big one there is assisted suicide. Is it an ethical thing? Some people say it's unethical to not help a person who's in pain and terminal and going to be dying within the next few days. So it's unethical to watch them suffer and not help them if they want to end their lives earlier. And other people say it's never ethical to do harm. And assisting suicide in their eyes is doing harm. So that's an ethical dilemma that I don't see ever coming to a conclusion. I mean, I don't see people agreeing on that one ever. Okay, so when we're talking about bioethics, which of course is ethics around healthcare, um, beneficence, the duty to act to benefit or promote the good of others, right? Beneficence. So you're benefiting others. Autonomy, respecting the rights of others to make their own decisions. And that can be hard sometimes because you aren't always in sync with them. I mean, they might be refusing medicines that are going to help them, but they're refusing it. Right now, we're kind of running into some of this where people don't want to get the COVID vaccine. In care, I remember taking care of people who are in religious beliefs that they will not accept a blood transfusion. It's like, well, you're going to have blood or you're going to die. And it can be a hard thing, but autonomy, it gives them the right, as long as they are mentally capable and in their own mind, they have the right to make their own decisions. Justice, on the slide there it says distribute resources or care equally. Now this here is regardless of personal attributes. You're going to allocate or devote equal attention to someone who's attempted suicide as you would to someone who's had a brain aneurysm. That's an example out of your book. And it's a good one. Fidelity, non-maleficence, maintaining loyalty and commitment, doing no wrong to a patient. Right? So non-maleficence. In other words, you're not going to do no malice, right? Veracity, the duty to communicate truthfully. So an example here it says in your book is describing the purpose and side effects of psychotropic medications in a truthful and non-misleading way. Mental health laws or statutes. Then they vary from state to state. Therefore, you're encouraged to review your state code to better understand the legal climate in which you're practicing. A lot of states went through a lot of revisions back in the 1960s. There seemed to be at that time an increasing awareness of the need to provide the mentally ill with uh, humane care. And this is humane care that respects each individual's civil rights. Once we started getting a lot of these uh, drugs, antipsychotic drugs and things that can mood stabilizers, things that can help patients, we kind of started realizing, hey, maybe we can kind of integrate some of these people into the larger community rather than shutting them off and just sticking them in asylums away from everybody else. And also the Affordable Care Act, what we call Obamacare, back in 2010, I think is when it was finally passed. And that provides that insurance companies you need to have available for mental illness just like you do for physical illness. Admission procedures. Informal admission is sought by the patient. Voluntary admission sought by the patient or guardian. Involuntary commitment without the patient's consent. And that there can be somebody has to be shown to be mentally ill, they're a danger to themselves or to others, and they're unable to acquire basic necessities. So now this informal admission, it's kind of confusing now when we say that it's sought by the patient, but what it is it's the least restrictive of all admissions. It's similar to any general hospital admission in which there is no formal application. The person does not pose a substantial threat or harm to himself or others, or I should say to self or others. Under this model, the normal caregiver-patient relationship exists. The patient is free to stay or leave and can leave against medical advice. Now, when we're talking about voluntary admissions, the patients apply for writing for admission to the facility. The person must understand the need for treatment and be willing to be admitted. If the person is under 16, then they need the parents' permission. Voluntarily admitted patients have the right to request and obtain a release. Before being released, however, they need to be reevaluated. Reevaluation can result in a decision on the part of the care provider to initiate an involuntary commitment, according to criteria established by state law. And as far as involuntary commitment, state laws vary, but they address both the criteria for commitment and the process for commitment. The criteria for commitment are the legal standards that the court decides whether the admission is necessary. These standards include a person who is mentally ill, right, posing a danger to himself or others, right? They're afraid that if he goes home, you let him go home, which he wants to do, he's going to hurt himself or he's going to go out and kill someone else, then, okay, then that's a threat, so we will involuntarily commit him. If they're gravely disabled, unable to provide for basic necessities such as food, clothing, and shelter, and if they're in the need of treatment and the mentally ill and the mental illness is preventing them from seeking help on a voluntary basis. So if they meet those criteria, you can involuntarily admit them. That's the criteria. Now the process for commitment. This is also spelled out by different states, differently in different states. But they're all kind of down the same, in the same vein as far as the way they run. If you look in your book, it talks about like back in the 1930s, it was pretty easy to get somebody committed. In fact, like husbands sick of their wives come and say, yeah, she's blah, 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 and they just commit her. And your book, according to your book, it says that there have been places where in the charting it says the husband says one of the reasons that she needs to be committed, she's not doing the housework. Well, it's not really like that anymore. And we actually have a pretty complex system for involuntary commitment. Generally, involuntary commitment begins with someone who is familiar with the individual and believes that treatment is necessary. Often when things become unbearable, A call is made to the police or local mental health facility. I can't take it anymore. He's not himself. Can you help us? Right? These kind of things. The person making the call might be a family member, legal guardian, custodian, or someone who lives with the individual. Could also be a healthcare professional. At this point, though, the individual becomes a formal application for admission. Or I'm sorry, at this point, the individual begins a formal application for admission. To support the application, a specific number of physicians, usually 2, or a combination of other mental health professionals, certify that a person's mental health status justifies detention and treatment. Now here in Iowa, I know I've had to do this many, many times. If somebody comes into the emergency room, a family member brings them into the emergency room, and the person is way off, and the person's maybe suicidal, or they're definitely a danger to themselves. Once the emergency room physician sees that, he will be one physician that agrees this person needs to be committed. And that means he needs to be involuntarily admitted to the hospital. We'll call the psychiatrist, explain the situation to the psychiatrist. The psychiatrist may agree, and then the psychiatrist is the one who has to write the order for admission into the hospital. But the ER doctor then will notify a judge and explain, I believe this person needs to be committed, and so does the local psychiatrist, and then the judge will give a court order for the person to be committed. And it's usually to hold them for as long or no longer than 48 hours. That doesn't mean the person will be there for 48 hours, because the psychiatrist will come in the morning and see them. And if the psychiatrist feels, I don't really agree with everything here, the way the ER doctor explained it, I don't think the patient is that bad, or maybe the psychiatrist says, after a good night's sleep, this patient doesn't seem too bad. I don't think they're suicidal. I'm going to go ahead and release them. So now they've only been in for 12 hours, but they had a 48-hour commitment. So that's what I'm trying to point out, is that just because it's a 48-hour commitment, that means you can hold them involuntarily up to 48 hours. And within that time, you can get the rest of the commitment. Now, when the psychiatrist comes in, they might let them go, or they might commit this person. Right? They might commit them for longer than the 48 hours. In fact, they will commit them until they think they are no longer a threat to themselves. Here we're talking emergency commitment. A person confused or demented, emergency admission, used for observation, diagnosis, and treatment, generally for 24 to 96 hours. Like I said, in Iowa, it's 48 hours. Court hearing before discharge or next admission. Assisted outpatient treatment, and it's a court order. And these are the emergency. I kind of got ahead of myself on that last slide, but these are the emergency commitments, the involuntary. Now, okay, we got an audience response question here. Which individual may need involuntary hospitalization? A person with alcoholism who has been sober for 6 months but begins drinking again. They need to be voluntary, right? They aren't in need of a involuntary hospitalization, right? So let's see. B, an individual with schizophrenia who stops taking prescribed antipsychotic drugs. No, by just that information that they're giving us, they do not need to be involuntarily committed, or that you don't have the right to involuntarily commit them. Let's say that. You don't have that power. They still, at this point, have the right to not take their medicine. Now let's see. C, an individual with bipolar disorder, manic phase, who has not eaten for 4 days. Okay. That person is not eating for 4 days. They do not have the mental capability to meet their basic needs, right? So they're a threat to themselves, and they're not, they don't have the mental capacity to take care of themselves. So even though they may not feel they need to be admitted, they will probably be involuntarily uh, admitted. Now let's see. D. Someone who repeatedly phones a national TV broadcasting service with new tips. Yeah. Well, no, they might be kind of irritating, but you aren't going to commit them. Due process and involuntary voluntary commitment. The writ of habeas corpus and least restrictive alternative doctrine. Well, let's see, writ. The first thing is that you know that writ is a procedural mechanism used to challenge unlawful detention by the government. So a patient who believes that he or she is being held without just cause can file a petition for a writ of habeas corpus, which means a full written order to free the person. So that's what the writ of habeas corpus is, right? So the writ of habeas corpus is the procedural mechanism used to challenge unlawful detention by the government. The hospital must immediately submit the document to the court. The court must then decide if the patient has been denied due process by law. Patients can also challenge the hospitalization based on the least restrictive alternative doctrine. The least restrictive alternative doctrine mandates that care providers must take the least drastic action to achieve a specific purpose. For example, if you can treat someone safely for depression on an outpatient basis, hospitalization would be too restrictive and unnecessarily disruptive. Discharge procedures. Conditional release, unconditional release, released against medical advice, the AMAs. Release from hospitalization depends on the patient's admission status. As previously discussed, voluntarily admitted patients have the right to request and receive release. Some states, however, do provide a conditional release of voluntary patients, which enables the treating physician or administrator to order continued treatment on an outpatient patient basis if the patient needs further care. And that's a conditional release, right? It usually requires an outpatient treatment for a specific period to determine if the patient follows the medication regimen, can meet basic needs, and is able to reintegrate into the community. Now, an unconditional release is the termination of patient-institution relationship. This release may be court-ordered or administratively ordered by the institution's officials. Generally, the administrative officer of an institution has the discretion to discharge a patient. So an unconditional release, right, is the termination of the the patient and the institution's relationship. So AMAs, against medical advice. In some cases, there is a disagreement between the mental health care providers and the patient as to whether the continued hospitalization is necessary. In cases where treatment seems beneficial, but there is no compelling reason or danger to the self or others, right? So there's no compelling reason to seek an involuntary continuance of stay, the patient can leave against medical advice. And that's just saying, the doctor's saying, I don't think you should go yet. Patient saying, I want to go. And the thing on that is, it kind of, the doctor doesn't want to still be on the hook for this patient's care because it's like, no, I would not release you. So they don't want to release me. It's like, this is against my advice, but he's going to leave anyway. He's going to use his right to make his own decision, and he's going to leave against my medical advice. Patient's right under law. Let's see. Right to treatment, right to refuse treatment, and right to informed consent. Right? So they have the right to be treated, and they have a right to refuse being treated, and they have a right to be informed of any procedure or anything that's happening, right? So that they're not just giving consent and not knowing what they're consenting for, right? They have a right to know. So the right of informed consent indicates that the patient has been provided with basic understanding of risks, benefits, and alternatives to any treatment. The person must voluntarily accept treatment. And that's why a lot of times the consent, we have a consent form. And to be effective legally, it must be informed, and in general, a physician or advanced practice provider must obtain the consent. Case study. JS, a 27-year-old male, is court committed by his parents to your unit with a diagnosis of paranoid schizophrenia. He lashes out at staff when they attempt to give him his medication. He states, "You're trying to poison me." JS continues to argue with staff. He's not aggressive, but refuses all treatment. Legal and client's rights are suspended when the client is hospitalized involuntarily. Is this true, false, or depends on the state, or depends on the physician assessment? It's just plain old false. Their rights are not suspended. The family of JS asks you, can you force him to take his medications? How do you respond? Well, patients who have been committed retain their right to refuse treatment. However, in an emergency, to prevent a person from causing serious or imminent harm to themselves, the individual may be medicated without a court hearing. So in that case, you got somebody out there thrashing about and fighting with everybody and hasn't been taking care of himself. You may have to hold him down and give him a shot. You know, maybe some Haldol and I don't know, diazepam or lorazepam or something to calm them down. Following the court hearing, a person can be medicated if he or she meets all of the following criteria. The person has a serious mental illness. The person's ability to function is deteriorating and he or she is suffering or exhibiting threatening behavior. The benefits of treatment outweigh harm of treatment. A person lacks the capacity to make a reasoned decision about the treatment, and less restrictive services have been found to be inappropriate. So in that case, once the court has met these criteria, you can actually give the patient the medication, even though he might be refusing it. Before that, like I said, if there's a big-time emergency and you have to deal with it right now, you don't have to wait for the court's decision. But normally on commitment, they do maintain the right to refuse care until we have determined that that would be harmful to the patient. Oh, and back on that last slide, we determined that it'd be harmful to the patient, and the patient's mental state is not does not put that patient in a position to make the decision for themselves. So eventually, JS agrees to electroconvulsive therapy, ECT. Which member of the team is responsible for obtaining the client's informed consent? And like we were saying earlier, and it's in your book, there are procedures, any kind of little surgeries or any kind of procedure, and it specifically mentions ECT. The physician or the person ordering it needs to obtain the consent. Okay, so legal considerations, we got HIPAA there, right? And confidentiality after death. So you can do damage to a person's reputation after they've died. So you need to remain, or I should say, you need to follow the rules of confidentiality even after the person has died. It's like, oh, well, he's died now, I can say whatever and I can tell everybody everything that happened to him. No, you can't. As far as confidentiality or professional communications, it's on a need to know. If a medical professional needs to know the information on a patient, then of course they have the right to read the chart and find out that information. If they don't need to know, it doesn't matter what position they're in, right? Then they don't have that right. So it might be a physician, might be a nurse, or whatever, but if they're not caring for that patient, they don't have the right to look into that person's stuff. Let's see. And then HIV, it's got that on there because that was a real big thing on confidentiality. Because a lot of healthcare people wanted to know if a person had HIV and they felt that they had the right to know. If they were caring for the patient, they probably did have a need to know that because it might affect the way they give care. So exceptions to the rule. Duty to warn and protect third parties. So if you're taking care of a psychiatric patient and they say, I'm planning on poisoning my wife, well, you don't only have the right to tell the wife, you have the duty to warn that wife that, he says that he wants to poison you or however, and you don't only just tell him he wants to kill you. He says, you tell him how, so that person knows what he's in for. And child and elder abuse, same thing. It's not only that you have a right, you have a duty, right? As you are a mandatory reporter to report these things. Tort law. Unintentional tort is unintended acts against another that produce injury or harm. And that could be negligence or malpractice. Intentional tort, intended acts against another to produce injury or harm, and that one could be assault, battery, or false imprisonment. And by the way, tort law is when a person wrongfully harms another, and the injury can seek money for damages from the responsible party. 5 elements to prove negligence. Duty. Nurses represent themselves as being capable of caring for patients. So when nurses represent themselves as being capable or caring for psychiatric patients and accept employment, a duty of care has been assumed. If there's a breach of duty, they do not meet the standard of care that is expected. Cause and fact. So they're saying if it were not for what the nurse did or failed to do, would this injury have occurred, right? In other words, was there a cause, in fact? So if the nurse had a breach of duty, but it didn't really have anything to do with the harm that was done, then the nurse got lucky, right? Because there's no cause in fact. But, proximate cause. So proximate cause, were there any intervening actions or persons that were cause of the harm to the patient? Now, it might not be the direct cause, but the results were foreseeable, right? You can see that what is happening here, what you're doing, is going to lead to harm to the patient. And last but not least, damages. So to prove negligence, there has to be damages, actual damages, loss of earning medical expenses or property damages, pain, suffering, whatever. It's got to be some damages. Guidelines for ensuring adherence to standards of care. In your professional life, you may suspect negligence on the part of a peer. In most states, you have a legal duty to intervene and to report such risks of harm to the patient. It's important to document the evidence clearly and accurately before making serious accusations against a peer. Your book gives an example of working with somebody who has a soda can and probably has alcohol in it. You notice that she's drinking this bottle of soda and probably catching a little buzz and maybe getting, I think it says on here, some slightly slurred speech. This is how should you respond? In less dangerous situations, the first step might be to communicate directly to the colleague. But in this case, where you see the person possibly ingesting intoxicating beverages, you have an obligation to immediately communicate your concern to the supervisor. The supervisor should then intervene to protect the patient's rights and well-being. If the supervisor is unavailable or unresponsive, you have no choice but to act to protect the patient's life. If you do not intervene, the patient may be injured and you may be liable for these injuries. A record's usefulness is determined by evaluating how accurately and completely it portrays the patient's behavioral status at the time that it was written. And of course, this is evaluated later when it's read later. Now, the purpose of medical records are to provide an accurate and complete information about the care and treatment of patients and to give healthcare personnel a means to communicate that care over time. Now, the patient has a right to see their medical record, but it belongs to the institution, because some people say that my medical records belong to me. It's like, no, it doesn't, but they do have a right to see it. The patient must follow an appropriate protocol in order to be able to see the records. Now, some things that the medical records are used for quality improvement, right? They can be reviewed and you can see places where maybe we can have process that will improve the quality of care. And it can be used as evidence very often. It might be brought out as evidence. And you got to remember too, a lot of times when you go to court, it's not usually like a patient that you documented this last week. It's usually like a year ago. In fact, every time I've been called out, the documentation I had to look at was like a year ago. Sometimes I didn't even remember writing it. So you want to write it down pretty well and draw a pretty good picture, if not for everybody else, for yourself, because you never know when you might need it. And there is a growing use of electronic documentation, of course. But just remember, medical records are used as evidence. Forensic nursing. The evolving specialty of forensic nursing includes the application of nursing principles in a court of law to assist in reaching decisions that have been contested issues. The nurse often educates the court about the science of nursing. The witness applies nursing knowledge to the facts in the lawsuit and may provide opinions using appropriate nursing standards. Some situations in which a psychiatric mental health nurse may be helpful include testimony related to patient competency, fitness to stand trial, is the patient fit to stand trial, involuntary commitments, or responsibility for crime. Forensic nurses may also focus on victims and perpetrators of crimes and violence. Part of the collection of evidence and the provision of health care in prison settings. Violence in psychiatric nurse setting. Let's see. Employers are not typically responsible for employees injured due to patient violence. Nurses must participate in setting policies that create and maintain a safe environment, always document patients' potential for violence, and communicate these observations to your colleagues. Don't just keep it to yourself. And in your book, it says between 2011 and 2013, there were 15 to 20,000 workplace violence-related injuries. So this number of healthcare injuries accounts for nearly as many injuries as in all other industries combined. Although emergency room nurses are more likely to be assaulted, psychiatric nurses also have fairly high rates of assault. Now, nurses as citizens have the same rights as patients do to not be threatened or harmed. In recent years, nurses have actively sought workplace violence legislation. New laws enhance criminal charges and penalties for striking nurses and other healthcare workers in the course of duty. Usually, a prosecutor will not bring charges against disoriented, delirious, psychotic, or otherwise mentally impaired patients. However, violent patients, friends of patients, and family members who are aware of their actions can be charged with serious crimes. I think that's pretty obvious, right? If they're aware of what they're doing, they can be charged. A nurse was a case manager for a client with a serious mental illness for 6 years. The client died by suicide a week ago. Today, the client's spouse asks, I always wondered if my spouse was a victim of sexual assault abuse in childhood. What can you tell me about that? Can the nurse disclose this information? Um, no, right? Just because the patient died, you can't tell them. Now, you couldn't legally tell them that when they were alive. You can't legally tell them that when they're dead. Now, when the patient was alive would have been the time for the spouse to ask if they really wanted to try to help the patient or find out for whatever reason. That would have been the time, because no, as the caseworker, this person, you will not be able to divulge any confidential information.